Law of tort. Definition, essentials, and ingredients. 1. Preface. Tort is a civil wrong committed by one party against another, violating a legal duty owed to the injured party. The primary objectives of tort law are compensation, to reimburse the victim for damages; deterrence, to financially penalize the wrongdoer and discourage future violations; justice, to restore the injured party's rights through legal remedy. Unlike criminal law, tort law is rooted in common law and addresses private wrongs where compensation, not punishment, is sought. 2. Meaning and definition. Etymology. Derived from the Latin word tortum, to twist, conduct. Wrongly. Legal definition. A tort is an act or omission that causes legally recognizable harm, injury, loss, or damage, entitling the victim to judicial remedy, usually monetary damages. Example: if a trespasses on B's land without permission, A commits the tort of trespass to land. 3. Wrongs that are not torts. The following are excluded from tort law. Criminal wrongs, for example, theft, assault, tried under criminal law. Breach of contract governed by contract law. Breach of trust falls under equity, fiduciary law. 4. Kinds of torts: intentional tort, negligence tort, strict liability tort. 5. Essentials of tort. Key ingredients for an act to qualify as a tort. All the following must be present. 1. Wrongful act or omission. The defendant must have committed a legally wrongful act violating a duty imposed by law. Mere moral or social wrongs do not constitute a tort. 2. Legal damage, injury. The act must result in violation of a legal right, for example, property, reputation, bodily harm. Injury or sign damno. Violation of right without actual loss is actionable. 3. Legal remedy. The law must provide a judicial remedy, typically monetary compensation. Ubi jus ibi remedium. Where there is a right, there is a remedy. 4. Civil nature. Not criminal. Tort cases are civil suits, not criminal prosecutions. The burden of proof is balance of probabilities, not beyond reasonable doubt. 5. Right must be legally recognized. Only rights protected by law, not moral. Social rights are enforceable. 6. Nature of tort law: uncodified, mostly based on judicial precedents. Case laws, dynamic, evolves with societal changes, for example, cyber torts, privacy laws. Compensatory, focuses on restoring the victim, not punishing the wrongdoer. 7. Position in Pakistan. Tort law lacks statutory recognition and is rarely invoked independently. Most tort claims are merged with civil or criminal proceedings. Similar trends exist in other developing nations, for example, India. 8. Objectives of tort law: compensation, to reimburse victims for losses; deterrence, to discourage wrongful conduct via financial liability; justice, to uphold civil rights and restore equity. 9. Conclusion. Tort law serves as a shield for civil rights, ensuring victims receive fair compensation while discouraging wrongful acts. Its flexibility allows adaptation to modern challenges, though its enforcement in Pakistan remains underdeveloped.